Now let's talk about the legal research process. What is our role? As lawyers, we are first and foremost peacemakers. Thus, when a client comes to us, we listen carefully, presuming nothing and suspending all judgments. We also give counsel, informing them of their options and the risk involved in each option, usually through a legal opinion. We also advocate, defend, or prosecute through pleadings such as legal memorandum. Now that we are clear with our roles as lawyers, let's proceed with the legal research process. The first step is to determine the issue. Let's say Maria's pet dog was kicked by her father and Maria witnessed the incident. What is the legal issue? What does the law say? Let's first categorize the problem. Since this is a criminal problem, then let's use updated commentaries on criminal law and search the elements or requisites. We can then find that under RA 9262, psychological violence includes allowing the victim to witness abusive injury to pets. We can then proceed to determine the factual issue. Did Maria witness the kicking of the dog? We can find this by interviewing Maria to make pleadings such as complaint with attached affidavits. We could also look for object evidence such as pictures of the bruised part of the dog as exhibits. And we could also use testimonial evidence, which is usually recorded in the transcript of stenographic notes or TSN. Just make sure to capture in your statement of issue the gist of the specific violation of right that the defendant committed. So in this case, the issue could be phrased like this: whether Juan's act of allowing his daughter to witness his kicking of her pet dog is a violation of RA 9262. It's also important to know the kinds of issues. As we gather resources, we may encounter multiple legal disputes. Thus, it is important to tackle them in the following order. First, threshold issues. Threshold issues take precedence over the main legal disputes. Examples of threshold issues are jurisdiction, real party in interest, or prescription in filing the action. Second, we have principal and incidental issues, where the incidental issues depend on the resolution of the principal issues. For instance, whether respondent is liable for damages would depend on whether respondent is negligent. Now that we have formulated the relevant issues, we can then proceed to the facts of the case. In narrating the facts of the case, make sure to include only information that are relevant to the resolution of the issues. Dates may be dispensed with if they are unnecessary, as long as the events are chronologically narrated. Also, use simple past tense in narrating the facts of the case. In writing a legal opinion, address the person asking for opinion. Example: the facts as I gather from you are as follows. And in writing a legal memorandum, use third-person pronouns. For example, they entered into an agreement, or she filed the complaint. Once you have gathered relevant facts, issues, laws, and jurisprudence, you can then proceed with the discussion or the arguments of the case. In writing the arguments, make sure to have an outline following the order of the statement of issues. This serves as a roadmap as you write your arguments. Make sure to deliver the strong points first. This means that You have to attack the loopholes of your own arguments until they are airtight, and you have covered all the bases. When you are done with the discussion or arguments portion, then you can proceed to the reliefs sought. First, state the specific reliefs sought, such as amount of actual or moral damages. Then, include a general relief, which is usually phrased as follows: all other reliefs as may be just and equitable. So that's it for our legal research process. Thank you for listening.